Welcome everyone, Australian Government and Statutory Interpretation, Topic 8. Finally, we get to our statutes and their interpretation. The wonderful world of statutory interpretation. So, when we say statutes, the term is functionally equivalent to acts, but I should note the principles of statutory interpretation that we're going to be looking at over the next few weeks also apply to regulations and other legislative instruments, so delegated legislation, subordinate legislation, which may be made by the executive and their delegated legislative power, as well as Parliament. So the principles we're going to talk about apply to interpretation of all kinds of laws. But what kind of process are we talking about? Well, the courts are indeed executive decision makers who have to determine the limits on their statutory powers or how best to implement their statutory powers, have to determine the legal meaning of legislation based on Parliament's intention when it enacted the legislation. So we're talking about the process whereby the courts determine the legal meaning of the legislation. And to add a little bit of complexity, the interpretation of legislation handed down in cases then becomes common law. Now, traditionally, common law was the predominant paradigm and source of law. However, statute law is slowly getting bigger, because you can imagine when federation was young, statute law used to be fairly confined. There were relatively few statutes on the Commonwealth law books. But then over the last century and a bit, there are now thousands which pretty much control all aspects of our lives. The article Statutory Universe by former Chief Justice Robert French in our reading, there's a link there in the module, first page of the module for week 8, talks to this statutory universe that the law pretty much is nowadays. It's all a statutory universe. So we've got legislation relating to the registration of births, deaths and marriages. If you run a business, all sorts of regulations. Government refers to this as red tape. You have regulation when it comes to universities as well. So the Royal Melbourne Institutes of Technology Act 2010 is a Victorian statute, but that's ultimately where you find the authority and rules under which our Chancellor, Vice-Chancellor and other university senior executives get their power to organise and run the university. I've put a link up there, APH statistics. If you look in that link, there's some stats from Australia Parliament House about the hundreds of bills passed in the most recent year alone. And if you have a look at the first part of chapter 9 of your textbook, you'll also see that this has been a growing trend. And you've got Lisa's PhD, which was measuring and gathering statistics on the volume of data, the volume of legislation passed, and then analysing that data to show you statutes per year and that sort of thing, and the increase over periods. Some statutes which you'll deal with in your practice as a lawyer, especially in the commercial area, are huge. So the Corporations Act, or particularly the Income Tax Assessment Act 1997, runs to more than 5,500 pages. It had originally to be divided up into 12 volumes. And this was because the official versions had to be printed. But they have actually retained that practice, still those volumes, for the online versions, and probably to make the PDF format versions size of the data manageable. We've got legislative instruments. So these are regulations, ordinances, ministerial directions, other things like that are even more numerous. I mean, it's almost impossible to get statistics on all of them because they're not really gathered in one place. But, for example, there's a link there I've provided, the Australian Parliament House website. You can see let's select a legislative instruments table from 2015, which lists nearly 300 which were tabled at that year. It is also important to note that only some legislative instruments, the ones that are disallowable by Parliament, so the ones which Parliament can actually override, they're the only ones that need to be tabled. So, and there are hundreds, if not thousands more each year, which are not tabled and which may only be available, for example, on the website of the department or the minister actually making them. So, some of the issues we're going to have to think about this week when it comes to statute law and statute law generally and its interpretation. Well, we talked about scrutiny, didn't we, of legislation last week when we talked about the select committees looking at the enactment of bills trying to give effect to international law obligations. So these scrutiny committees of Parliament, do you think can they? Because they're supposed to check bills for consistency, for drafting errors, for compliance with common law rights, and as we saw, the international covenants last week, international human rights law. So these committees, their task is to scrutinise every piece of legislation that comes before Parliament, and then between acts and legislative instruments, there are hundreds and hundreds of those every year. And don't forget that Parliament's not even in session for a significant proportion of the year. So how easy do you think it is for those scrutiny committees to really properly scrutinise this huge volume of legislation which is put out by Parliament each year? Another important point to note is there are unofficial versions of legislation floating around all over the internet. For example, AGSI is very diligent at putting up new legislation, and it's sometimes the best way to do comparative analysis of legislation between the Australian jurisdictions. But it is not the authoritative government source for that. You really need to go to the official legislation website of each jurisdiction. And we've already looked at, for example, legislation.gov.au, but there's also legislation.vic.gov.au and then similar sites in the other states and territories. Keep in mind that we discussed earlier on in the course of different kinds of law which we're subject to under our constitutional arrangements. We've got constitutional law, so the Constitution itself. We also have common law or judge-made law. So you need to keep in mind where statute law sits in that hierarchy. It's a binding law enforceable by the courts, but subject to constitutional constraints. So we know statute law ranks below the Constitution in our legal hierarchy in that sense. But then think about the other sources of law we've discussed. There's the common law, there's international law, there's the common law of other jurisdictions, there's statute law, clearly, especially in Australia, where the doctrine of parliamentary sovereignty is strictly adhered to. So our statutory law is clearly going to outrank these other sources of law within the legal hierarchy of Australia, subject to the Constitution. And then finally, think about amending the law. So the common law can just be changed quite easily when a new case is decided. We briefly looked at the process for amending the Constitution, which, as we know, requires a referendum, which we're now going through with the voice. But what about the process for amending a statute? We've discussed in some detail how a bill makes its passage through Parliament when we talked about parliamentary processes in weeks 1 and 2. But what if it's not a new law, or it's just an amendment? So how does a statute get amended? And what if just one word needs to be changed? So we'll have a look at that, and we'll discuss these questions in our tutorial. All right, so that gives us a lovely segue into the focus for this topic, which is obviously the interpretation of statutes. As I said, these govern all aspects of our lives and are particularly important when people are undertaking trade and commerce. We want certainty in the world. We need reliability. We need to know what it is we're doing. Imagine there's a strata plan there. Imagine buying an apartment for $1 million. You need to know what you're getting. So interpreting statutes is a vital skill for legal practitioners, but also anyone who needs to apply statutory provisions. So business owners. There may well be a need to be aware of a specific statutory provisions in their area, or they might hire you, their lawyer, to be aware of the relevant statutory provisions on their behalf. So we want to start thinking about how we go about determining the meaning and how to apply the law of statutes, and then how that relates to the public law principles we've been talking about. So whose job is it? Constitutionally speaking, whose role is it to interpret and apply the statutes? Well, it's the role of the courts. But we've also looked at depth at the separation of powers. So the courts must do the best. They've got to perform their role independently, but they can't usurp the role of Parliament, which is to make new law. So we're going to look at Taylor and Owners of Strata Plan 1156-4, a High Court case. Chief Justice French, as he was at the time, Justice Crennan and Justice Bell, they said in Australian law, the inhibition on the adoption of the purposive approach or of construction that departs too far away from the statutory text has an added dimension, because too great a departure may violate the separation of powers in the Constitution. Wow, so have a think about that. You've got an Act of Parliament, you've then got the courts trying to give effect to it, saying, oh, well, we're going to try and find a purposive approach, but there's even a limit on that. It's got a dimension, because too great a departure from the words may violate the separation of powers, because they've found an interpretation that's beyond the meaning or the natural or the words of the text of the legislation. We'll come back to that case later on today. So we'll come to purposive construction, what that means in a moment. But what their honours are trying to emphasise in this case is the courts have to stick to what Parliament has written to the greatest extent possible. Because if they're not implementing Parliament's will, if they're implementing their own will, well, then they will transgress the boundaries of their constitutional role. So the correct interpretation of the law is often disputed, as you can imagine, and that's what forms the basis of a great number of lawsuits. And although the courts are barred from making law, it can't just say the law means something completely different to what it says. In most cases, the court does have the final word constitutionally on the correct interpretation when that interpretation is disputed by the parties. That's the contention. That's the matter before the court. So why is it important that this role goes to the court instead of the executive? Why can't the executive just decide for itself how the law should be interpreted and applied? Even if a citizen says, no, that sounds like an incorrect interpretation of Parliament's intention to me, wouldn't it be more efficient if the executive could just say, well, this is the way we interpret it and our word is final? Just as an aside, when it comes to international law, which we discussed in some depth last week, sometimes that is how it works in Australia. As you recall, the executive has the sole responsibility for entering into treaties and making other international agreements for Australia. And then in some cases, the executive's interpretation of a treaty is final. And the courts can only become involved if that treaty has made its way or transformed into domestic law. But what if the law being contested is discriminatory or otherwise tramples on people's rights? Can the courts reinterpret it in such a way as to fix the discrimination, so they depart from the sort of natural or dictionary meaning of the statutory provision? We're going to have a look at this later on this topic, and going to dive much deeper into it for topic 9. Okay, so what do we actually mean by statutory interpretation or construction? So more specifically, we know it's about finding the right meaning, but is it the grammatical meaning, like the dictionary meaning, like interpreting a language? The answer is no. It's a specialized task that lawyers and courts are particularly concerned with, and it is the search for the legal meaning of a piece of law. So that's the meaning as conveyed by the text, read in its context, in relation to its purpose, which courts sometimes call the mischief, which the law is seeking to resolve. So if you think of most laws and regulations passed by Parliament as intending to fix a certain situation or alter a certain situation, in our society, or perhaps alter people's behaviour or stop people from doing certain things, or indeed making people do certain things, pay licenses, etc., then those things might be considered mischiefs, which Parliament is seeking to resolve. Now, the person interpreting the law has to be aware of existing legal principles and the constitutional framework in which they're working. So this is one of the reasons why it is appropriate for the courts to have the final say in this. They should see the instrument as a whole, so that we'll have to have a look at some cases where the meaning of a provision does seem fairly apparent at first blush, but if you then zoom back out to the statute as a whole, it wouldn't actually make any sense, perhaps, to apply the literal meaning. When the court, in interpreting and applying legislation, seeks to achieve harmonious goals and alleviate conflict, ultimately it's resolving a dispute. Someone has to make a decision. It can't be circular and go on indefinitely. It needs a conclusion, and so the courts provide certainty in that regard. So the court's role in an adversarial system is to resolve those disputes between parties, and then those disputes involved the contested interpretation of law. The courts are seeking to alleviate or solve the conflict. And if there are any inconsistencies, for example, in competing provisions of law, it's also the court's role to determine, to the extent possible, what Parliament's intention was and what should then happen in those circumstances. Now, traditionally, there's been a fairly strict or literal approach to the interpretation of statutes, because the courts were keeping in mind their constitutional role of implementing Parliament's will and then not making law. But problems often result from a literal or a grammatical interpretation. For example, it could be read in a way that it obviously wasn't intended or even anticipated by the drafters of the law, and then exceptions needed to be made, for example, where the natural meaning of words might lead to an absurd result. So we'll look at some examples of that in class over the next couple of weeks. And then in cases of genuine ambiguity, so if the wording of the statute is genuinely ambiguous, the courts sometimes then applied what was known as the mischief rule, whereas they looked at the intention of the statute as a whole and then the mischief that Parliament was attempting to fix. So what was the mischief that the statute was seeking to resolve? And then eventually that rule expanded to give the approach of what we follow today, and in more recent times now known as the purposive approach. So the more modern approach focuses on the objectives, intention of Parliament in making the law, because the will of Parliament is supposed to be the guiding force, and the Diceian approach to the rule of law. Now, of course, that then leads to questions about how do you determine Parliament's intention or purpose, and we'll talk about that a little more in a moment. So the steps involved, which we're going to delve into much more depth in the next few sections, the task of statutory interpretation begins and always begins with the consideration of the text, like the words in front of you, the words on the statute, as you can imagine. However, then the text needs to be considered in context. So in the context of the act, like maybe the division or the part or the act as a whole. It then needs to be considered in the context of Parliament's purpose. So if almost all of an act is aimed at a certain purpose, like regulating a certain behaviour, but then there's an incongruous provision which is being litigated, the courts need to have in mind the rest of the act, sometimes for the provision to make sense. Then there can be also interpretative presumptions which come into play. So like common law presumptions which the courts follow or apply, even when they're interpreting legislation. Because of course it's a common law jurisdiction, isn't it? It's the courts. So assumptions, if you like, that they make about how Parliament enacts laws and why it enacts laws. And we'll then have a look at some of those in more detail in topic 9, like statutory presumptions. And then finally, the courts may need to then have resort to what are called aids to interpretation, or sometimes known as extrinsic materials, that is, external to the statute itself. These could be like second reading speeches, ministerial statements about the purpose behind passing certain laws, Hansard, which is the formal register and copy of Parliament debates in Parliament, if the laws were debated in Parliament. And so some of those materials may, if the meaning's not already apparent, they might have discussed the text, context, and purpose. They might be helpful to elucidate the meaning of like a tricky provision in front of the courts in the current dispute. So the modern approach we've turned into the purposive approach. That is to try and find the purpose of the statute and interpret any provision in light of the purpose of the statute. And this is in fact in turn mandated, somewhat circularly, by legislation itself. So in each jurisdiction we've got an Act of Parliament focusing on guiding the interpretation of Parliament's other acts, all the other statutes. And a particular note for the purposes here would be the Acts Interpretation Act 1901 Commonwealth, section 15 AA, which says, in interpreting a provision of an act, the interpretation that would best achieve the purpose or object of the act, brackets whether or not that purpose or object is expressly stated in the act, is to be preferred to each other interpretation. All right, so any ambiguity, you interpret it in a way that would best achieve the purpose. And likewise, we have a similar provision in the ILA where the state government of Victoria is mandating under section 35, the Interpretation Legislation Act 1984, Victoria, in the interpretation of a provision of an act or a subordinate instrument, a construction, which is another word for interpretation, that would promote the purpose or object underlying the act or subordinate instrument, whether or not that purpose or object is expressly stated in the act, shall be preferred to a construction that would not promote the purpose or the object. And notice the word shall. So that's a mandatory thing. So it's Parliament saying to the courts, have due regard to our purpose in passing this law. Parliament stamping its authority, if you like, emphasising that under our constitutional arrangements, Parliament's will should be done. Now, we should also note the Acts Interpretation Acts and then the other similar acts at the state level. They also set out other helpful general rules, such to do as when, like, old acts only refer to he or his, or what to do when they refer to certain date ranges in odd formats, other things like that, distances. So they've got a whole range of guides to interpretation. But these two provisions, so you need to burn these into your brain, the AIA, section 15AA, and the ILA, section 35. These provisions are the ones that determine the overarching purposive approach which the courts are mandated by legislation to take these days. All right, we'll leave it there. I'll come back in part 2.